So, an important point to realize about novelty rejections is that when the examiner looks at the reference to use in a novelty rejection, they don't look at the claims. And this is also the case for obviousness rejections. What they're looking at is the description, the detailed description, the specification of the patent or a published patent application. And they're looking to that specification to find the technical language that describes something that's has to be the same, very similar to at least the limitation in question of your claim. Again, for a novelty rejection, if you have a widget comprising A, B, and C, then the examiner has to produce a reference, which could be could be a patent, a technical paper, or a patent application. And in that document, the examiner has to point to the sections that describe limitation A, limitation B, and limitation C. If the examiner isn't able to do that adequately, then the 102 rejection would fail. And as a patent attorney, I would argue against that. Or if the examiner points to a certain section of that document and says that this teaches limitation C of the patent claim, and technically, when I read it, I disagree. I don't agree that technically that section is teaching what the examiner is alleging it to teach, then I would argue against that. This is a typical type of back and forth argument that happens between patent applicants, patent attorneys, and the USPTO patent examiners. Now, the other type of rejection is obviousness, and that one is a little bit more esoteric and a little bit more difficult to understand. With obviousness, usually what the patent examiner will do is find a combination of references. So again, with the simple example of the widget claim having limitation A, B, and C, what the examiner might do is find one reference that teaches limitations A and B. The examiner will cite reference 1 as teaching limitation A and limitation B, and find a second reference, reference 2, and cite that reference as teaching limitation C. And what the obviousness rejection basically looks like is the examiner will say that a person having ordinary skill in the art, looking at reference 1 would see limitation A and limitation B, and looking at reference 2 would see limitation C. And it would be obvious to a person having ordinary skill in the art to combine reference 1 and reference 2 to arrive at your invention having limitation A, limitation B, and limitation C. And there's usually a motivation to combine those references that goes along with that argument that the examiner makes. For example, the examiner may make an argument of something like, if the person having ordinary skill in the art combined reference 1 and reference 2, it would improve reference 2 technology by adding the features and benefits of limitation A and limitation B, whatever they may be. Now, there are different arguments that can be used against an obviousness rejection, and those are, again, there are more arguments that can be made than for novelty. And in the case of a novelty rejection, you're either looking to see that the reference isn't teaching one of those limitations, maybe the reference doesn't teach any of the limitations if the examiner is misunderstanding that reference or misunderstanding the claim somehow. And then you can argue that the examiner has erred in making that assessment. Or if you find that the examiner is correct or correct in some aspect of the rejection, the other option you have is to amend the claim. And you amend the claim by either clarifying one of the limitations or adding another limitation. Clarification of a limitation in many cases can be sufficient to overcome the 102 novelty rejection. Now, for obviousness, that can work also, but because obviousness has these different aspects, it's a little bit more difficult to overcome the obviousness rejection. And I would say that probably 90% or more of the arguments that a patent attorney has to deal with from the USPTO rejecting patent claims are obviousness rejections. The novelty rejections are usually easy to overcome by, again, either determining that the examiner has made a mistake in the way that they've interpreted the prior art that they're citing, or that they're not interpreting the claim language correctly. Or in the worst case scenario, if the examiner is on target with finding those limitations of the claim in the prior art, then an amendment can usually be made to narrow the claim, to add a limitation, or to clarify one of the existing limitations to again have the claim be novel over that cited art. With obviousness, there are several different possibilities for how to argue. Now, one of them is similar to the 102, And sometimes that's the most effective argument, and I'm going to go into that in the next video.